5 seconds. The fundamental principle underlying the relationship between the state and its employee is that it is governed by administrative rules rather than contractual agreement. In view of the power of the state to modify the terms and conditions of services by unilaterally amending the rules, this kind of employment is defined as status. Therefore, when grievance of an employee is brought to a court or a tribunal, the primary question is about the rule that governs the services. At this stage, there is no value judgment about the executive action, unless, of course, when the rule itself is challenged on the ground of invalidity or arbitrariness. So we simply look at the role that governs the services and determine whether the action is in consonance with the mandate of the rule. The rule that govern the service of the respondent are the Karnataka Civil Services Rules 1977 and Karnataka Government Servants Rules 1957. The context in which interpretation and application of these rules are to be found in the facts of this case, which, to the extent that they are relevant for our consideration, as are given. The respondent was appointed as a staff nurse in the Department of Indian System of Medicine and Homeopathy, State of Karnataka, in the year 1979. She submitted a representation to the government and requested to change her cadre to First Division Assistant on medical grounds. Following her request, the government sought opinion of the director of the department, who asked the respondent to appear before the medical board for examination. The board submitted its report indicating that the respondent was in fact suffering from bronchitis and that she will not be able to carry out the duties of a staff nurse. Following the decision of the government accepting her request change of cadre, the respondent was asked to submit a consent letter, which she did, indicating that with reference to the above subject, I hereby give my consent for the offer to change designation to clerical nature of work in the pay scale of Rs 630, 1200 and to take seniority below the last person, accepting her consent to be placed below the last person in the transferred post, orders of temporary posting followed by final order was issued by the government changing the cadre of the respondent from staff nurse to First Division Assistant on medical grounds. The Government of Karnataka, the appellant herein, submit that the respondent continued in the new position as First Division Assistant to the place as was accepted by her from 1989 to 2007. However, when the seniority list was released in 2007, she approached the Karnataka Administrative Tribunal for challenging the final seniority list on the grounds that her seniority must be fixed as per her initial appointment as staff nurse on 5 January 1979 and not on the basis of her entry into the new cadre on 19/1 to 1989 as First Division Assistant. The tribunal allowed the original application by following the decision of the High Court in the state of Karnataka versus Shri K. Sitaram. The writ petition filed by the state of Karnataka challenging the decision of the tribunal was dismissed. The writ petition filed by the state of Karnataka challenging the decision of the tribunal was dismissed by the order impugned before us. This is how the state is in appeal. We heard learned counsel appearing on behalf of the state and the learned counsel for the respondent. The factual background as indicated herein above clearly establishes that the change of cadre from staff nurse to first division assistant occurred due to a request by the respondent, and the same was considered under the 1977 recruitment rules. To consider whether the final seniority list is legal or not, we need to examine the mandate of Rule 16, which is extracted herein for ready reference. Notwithstanding anything contained in these rules or the rules of recruitment specially made in respect of any service or post, the government may, for reason to be recorded in writing, appoint to a post 1 an officer to the defense services and all India services or a civil service of the union or the civil service of any other state to an officer holding a post of an equivalent grade by transfer or by deputation from any other service of the state for recruitment to which these rules apply, provided that appointment by transfer under this subclause shall not be made unless the officer has passed the examination prescribed under the Karnataka Civil Services Rules 1974 for the post to which he is proposed to be transferred. Provided further that where it is necessary in public interest to appoint an officer belonging to a service where has no equivalent grade, an officer holding a post in the next lower grade in such service may be appointed by deputation for a period not exceeding 2 years. Provided also that no such appointment shall be to a post which is equivalent to or higher than the next promotional post to such officer in such other service.